All right. Let's start with the session. A very good morning to all of you, and welcome to Unacademy. My name is Aditi Bhatt, and I'm covering your legal reasoning, current affairs, and legal current affairs from the daily The Hindu News Analysis. All right. So, before we proceed with the session, I want to tell you about my Telegram channel. You can join the Telegram channel wherein I daily upload the newspaper, the PDF version of the newspaper, and also updates regarding the class sessions, as well as certain notes which I'll be starting from today onwards. And in case you're planning to take on any of the Unacademy subscriptions, you can unlock free classes and subscription discounts by using the referral code ABCLAT. All right, so let's see what are the today's highlights. Okay, so the first article that we're going to talk about is many killed in riots in Manipur. Government issues shoot at side order. This is actually related to Methi tribal community, which is a majority community in Manipur, and they are being given the scheduled caste status. So that is why the riots are happening. All right. So we'll discuss about that. The second article is leg up for all tongues, no Hindi imposition, Shah. So Amit Shah has recently said that Hindi, we are not imposing Hindi on anyone, and that the government is trying its best and making all provisions, to promote all the regional languages, and we'll look into it in detail. Then the third article is Jay Shankar discusses LAC with Quinn, holds talks with Lavrov but not Bhutto. So this is related to geopolitics, but from international law point of view, we'll discuss what all international organizations have been talked about. Another article itself, SEO ministers meet today to discuss economic ties. Again, so some important international organizations and groupings have been mentioned in this article, so we will be discussing those as well. Then the last for today is stop caste survey immediately. High Court tells Bihar government. So this is about the caste census or the caste survey conducted by the state government. So state government, which is not authorized to take the caste census, was taking the caste census. That's why the High Court has stopped the Bihar government from conducting any more caste census. Okay, so let's start. So let's see the first article. First article is related to a Methi community which has recently been, there's a decision by the Methi community to basically the Manipur government has decided to grant scheduled tribe status to the Methi community in Manipur. Now Methi community is the majority community over there, and that's why there are a lot of protests being happening. A lot of clashes broke out after this decision, after this announcement by the state government, and they are basically saying that because it's a majority community and they have already adequate representation in various jobs and various fields, that's why they should not be provided with the scheduled tribe or the ST status. Okay, so let's briefly look into what the article is related to from your exam point of view. So it's related to, first of all, constitutional law subject, and we can talk about the reservations or the scheduled tribe. Then, as we discussed, Methi community. Now, before we discuss a lot about the scheduled tribe itself, let me tell you about the reservation provisions under the constitution. So you see, under the constitution there are certain reservation provisions have been provided in the constitution, right? Under article 15, 16, and especially for 15 and 16, specific reservations have been provided, and under article 29 and 30 there are different types of reservations that have been given there. Okay, so reservation regarding this thing, just a second. So reservation in the constitution is basically provided on the basis of four things. Okay, reservation has been provided on the basis of caste or tribe. That is, people who belong to certain caste or tribal community have been provided reservation. all right, because historically speaking they have been they required upliftment and empowerment. That's why they have been provided reservation. So reservation, the basis for reservation in our constitution is there are sort of four categories of people who have been provided reservation. First is, it is on the basis of caste or tribe. That is, people who are not adequately represented, people who belong to certain such communities, as in caste communities or tribal communities, caste based or tribal communities, who are not adequately represented. They are provided reservations so that they can be adequately represented in various public employment, right? Then second is and of course education as well. Then second category of people who are provided caste or sorry, who are provided reservation under the constitution are social and economically, or sorry, socially and educationally backward people. Okay, people who are socially and educationally backward, or SEBCs. Okay, who are also known as other backward classes, who are basically uh, can be categorized. 15 specifically talks about reservation in education, and 16 talks about reservation in public employment. Of course, there are specific provisions as well. So, if we see on an overall basis, there are the reservation under the constitution is provided on four different category, on four different bases. Okay, firstly, it is provided to people who belong to a certain caste or tribe. That is, they are provided a reservation on the basis of their caste or tribe if they are not adequately represented, right? Second is that they are provided the people who are socially and educationally backward, or people who belong to socially and educationally backward community, are provided reservation, or the other backward classes are provided reservation under the constitution. Then third category of reservation is the economical backwardness, third basis. So economically weaker sections are provided reservations, right? Just a second. And then the fourth category is the vulnerable section of the population. For example, women, children, senior citizens, or differently abled people, right? So these are the four categories, or the four bases on which the reservation has been provided under our constitution. Nowhere does the constitution mention reservation to be provided on the basis of religion or race or different other categories. Okay, now you can also look at this particular article from a criminal law perspective, if you are trying to understand the difference, or trying to understand the concept of riot, right? Because it mentions riot, difference between riot, affray, and other offenses. So we'll discuss on that later, but what I want you to understand is the scheduled tribe status, what this article is talking about, or what this article revolves around. Okay, so I have picked this information from the National Commission for Scheduled Tribe website, that is ncst.nic.in. You can also log into this website and read upon the details. So, first of all, let us understand who are scheduled tribes. Okay, so the framers of the constitution took note of the fact that certain communities in the country were suffering from extreme social, educational, and economic backwardness on account of the primitive agricultural practices, lack of infrastructure, facilities, and geographical isolation. The Constitution of India, under Article 366, Clause 25, prescribed that scheduled tribe means such tribes or tribal communities as are deemed under Article 342. Just let me write it here. So this website basically states that under Article 366, Clause 25 of the Constitution, it states that scheduled tribe means such tribes or tribal communities as are deemed under Article 342 of the Constitution to be the scheduled tribes. Okay, such communities which are mentioned under Article 342 of the Constitution. So now let's see what Article 342 talks about. Article 342 Clause 1 defines scheduled tribe. It states that president may, with respect to any state or union territory, and where it is a state, after consultation with the governor, it basically states that president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by a public notification, that is after consultation with the governor of the state, right, by public notification, specify the tribes or tribal communities or part or groups within the tribes or tribal communities as scheduled tribe in relation to that particular state or union territory, as the case may be. Because in every state or every union territory, the demography is different. There are different communities in different states and union territories, right? So there are, for example, if a particular community is in majority in one state, it may or may not be majority in the other state. It might be minority in a different state, or there are certain communities that are specific to certain states. Okay, there are certain communities which are only, you will only find those communities in those particular specific states. Okay, now, clause 2 of article 342 talks about, this was clause 1. Okay, clause 2 basically states, Parliament may by law include in or exclude from the list of scheduled tribes specified in a notification issued under clause 1 any tribe or tribal community or part or group within any tribe or tribal community, but save as aforesaid, the notification issued under the said clause shall not be varied by any subsequent notification. So what basically, I'll just make you understand कि ये जो दोनों articles हैं वो क्या बात कर रहे हैं, ठीक है? आर्टिकल 342 क्लॉज 1 में ये बोला जा रहा है कि प्रेसिडेंट हर स्टेट या यूनियन टेरिटरी में जहाँ पे भी शेड्यूल ट्राइब्स हैं, जो जहाँ पे भी कम्युनिटीज हैं, वहां पे एक नोटिफिकेशन, एक पब्लिक नोटिफिकेशन इशू करेंगे आफ्टर गवर्नर, वहां के जो गवर्नर है उनके कंसल्टेशन के बाद, कि वहां के जो भी, अगर जिनको कौन से शेड्यूल ट्राइब्स को पहले तो स्पेसिफाई करेंगे कि कौन कौन से शेड्यूल ट्राइब्स हैं, कौन सी कम्युनिटीज हैं, कौन सी ट्राइबल कम्युनिटीज हैं, ट्राइब्स हैं, ग्रुप्स हैं, विद इन द ट्राइब कौन कौन से ग्रुप्स हैं, राइट, वो सब पूरा एक स्पेसिफाई करेंगे. क्लॉज 2 में ये कह रहा है कि प्रेसिडेंट के पास पावर है, सॉरी पार्लियामेंट के पास पावर है अंडर क्लॉज 2 ऑफ आर्टिकल 342 टू इंक्लूड और एक्सक्लूड, किसी एक ट्राइबल कम्युनिटी को एक्सक्लूड करना या इंक्लूड करना एज पर द अमेंडमेंट, जो भी स्पेसिफाइड नोटिफिकेशन है उसके इन अकॉर्डेंस विद दैट. ऑलराइट, now what is the criteria for specification of a community as a scheduled tribe? So article, just let me just go back a little. Article 342 clause 1 is talking about the president, and article 342 clause 2 is talking about the parliament. Okay, all right, then what is the criteria for specification of a community as a scheduled tribe? So let's understand what the criteria is. Constitution is silent on what the criteria is. So there is actually no provision, let me write it here, no provision in the constitution regarding what is the criteria. So the criteria for excluding or including any particular community in a scheduled tribe is basically not present, it is absent. Okay, so constitution is basically silent about the criteria for specification of a community as a scheduled tribe. The words and phrase, what we need to infer is, there is this words, or there is a phrase basically mentioned under article 342 itself, which says tribes or tribal communities or part or groups within the tribes or tribal communities. This is what we have to infer, right? Under article 342 they have been understood. So what they have been understood, जो उनका interpretation है वो government ने कैसे निकाला है, उनका, they have to check the historical background of the tribe, What is the historical background, right? uh, and what is the historical background of backwardness? ठीक है, sorry, just a second, right? Then what is the whether the tribe is primitive, so primitiveness, right? Then whether the tribe is geographically isolated, so they also look into the geographical isolation of the tribe. All right. Then they also look into, whether the community is a slightly shy community, so there's shyness involved, and not interactive with the other. Shyness basically implies that they are not very interactive with the other members of other community, right? They are social, educational, and economical backwardness. So social backwardness, educational backwardness, and इकोनॉमिकल बैकवर्डनेस है, ठीक है, इकोनॉमिकल बैकवर्डनेस, ये सारे factors, these are the reasons, and due to these reasons they are the traits that distinguish scheduled tribe communities of our country from other communities. ये सारे basically factors या categories, reasons देखे गए थे, ठीक है. It takes into account the definition of tribal communities adopted in 1931 census. These facts are the basis for the provisions under Article 342 Clause 1, which mandates to specify tribals or tribe communities as part or groups within the tribal communities as a scheduled tribe in relation to every state or union territory. The list of scheduled tribe in state or union territory specific, and a community declared as a scheduled tribe in a state need not be there in another state, as we already said, right? So the presidential notification, तो क्या होता है, जो presidential notifications issue किए जाते हैं, वो जब भी किसी ट्राइब को, जब भी किसी कम्युनिटी को एसटी स्टेटस मिलता है, तो वो जो प्रेसिडेंशियल नोटिफिकेशन है उसको अमेंड किया जाता है, राइट? ओके, सो दैट इज अमेंडेड. जब भी कोई ट्राइब ऐड, जब भी कोई कम्युनिटी को एसटी स्टेटस दिया जाता है तो उसको अमेंड किया जाता है. दैट इज पार्ट ऑफ कॉन्स्टिट्यूशनल अमेंडमेंट ऑल्सो. The president notification under clause 1 of article 342, basically there are two constitutional orders state wise, ठीक है. So let's write another point here. The first backward class commission, the first backward class commission was which was headed by Justice Kalelkar, was set up in 1955. So first backward class commission set up हुआ था 1955 में. Okay, Justice Kalelkar commission, so known as, which in view of the demands from various quarters for specification of OBCs, this was for OBCs, right? The Kalelkar Commission submitted its report in 1956. The commission recommended for inclusion of scheduled tribe also to OBC. So, according to the commission, it was one of the recommendation was to include the scheduled tribes इन ओबीसीज, जो ओरिजिनली इंक्लूड नहीं हुई थी. मतलब उस ये कहने का मतलब है कि जो 1955 में फर्स्ट बैकवर्ड क्लासेस कमीशन सेटअप हुआ था, जो कि जस्टिस कलेलकर कमीशन था, राइट? उन्होंने अपनी रिपोर्ट 1956 में प्रेजेंट करी थी. तो जो भी ओरिजिनली, यानी जब कॉन्स्टिट्यूशन ड्राफ्ट हुआ था उस टाइम पे जो शेड्यूल्ड ट्राइब्स और सारे जो ऑलरेडी लिस्ट हो गए थे, पब्लिक नोटिफिकेशन बाय द प्रेसिडेंट इशू हो गया था, दैट वाज पार्ट ऑफ द कॉन्स्टिट्यूशन. तो ये हुआ था कि जो कमीशन आई उसने बोला कि जो भी ऐसी कम्युनिटीज रह गई हैं विच हैव नॉट बीन एडेड, मे बी बाद में ऐड हो या बाद में अगर ऐड होनी हो, सो लेट अस ऐड देम इन द ओबीसी कैटेगरी इटसेल्फ, यानी कि अदर बैकवर्ड कास्ट, अदर बैकवर्ड क्लासेस कैटेगरी. ऑलराइट, so they can be those who have been left out, those scheduled tribes who have been left out can be added in the other backward communities. Right. सो देन ऑफ कोर्स एक जस्टिस लोकुर कमेटी आई थी 1965 में, एक जस्टिस चंदा कमेटी आई थी. ओके, यू नीड टू अंडरस्टैंड कि उन्होंने भी फिर कुछ एसेंशियल कैरेक्टरिस्टिक्स बताए थे. ओके, और आज के टाइम में देर आर सर्टेन मोडालिटीज हैव बीन लेड डाउन फॉर डिसाइडिंग द क्लेम्स फॉर इंक्लूजन और एक्सक्लूजन ऑफ शेड्यूल्ड ट्राइब्स. ओनली दोज क्लेम्स. तो क्या होता है, देर इज अ प्रोसीजर, देर इज अ सेट प्रोसीजर इन टूडेज टाइम. only those claims that have been agreed to by state government. तो state government अगर कोई मतलब किसी state government अगर दोस बहुत सारे proposals आते हैं बहुत सारी communities के कि they want ST status. so state government जो भी proposals accept करती है उसके बाद वो रजिस्ट्रार और स्टेट गवर्नमेंट और उसके साथ रजिस्ट्रार जनरल ऑफ इंडिया, द नेशनल कमीशन फॉर शेड्यूल्ड ट्राइब्स, ये तीनों लोग मिल के रजिस्ट्रार जनरल ऑफ इंडिया एंड द नेशनल कमीशन फॉर शेड्यूल्ड ट्राइब व्हेन दे ऑल consider or approve the claims of any of those communities who are asking to be added in the scheduled tribes thing status, then the representation received by the Ministry of Inclusion of any community, the list of scheduled tribe, the ministry forwards the representation to the concerned state department, to the concerned state government or union territories administration for recommendation under article 342 of constitution. Right. तो अगर स्टेट गवर्नमेंट उस प्रपोजल को रेकमेंड करती है तो वो रजिस्ट्रार जनरल ऑफ इंडिया के पास जाता है. फिर रजिस्ट्रार जनरल ऑफ इंडिया जब सेटिस्फाई होता है तो फिर स्टेट सेंट्रल गवर्नमेंट को वही स्टेट गवर्नमेंट का प्रपोजल रेकमेंड करता है. वंस आरजीआई इज सेटिस्फाइड तो वो सेंट्रल गवर्नमेंट के पास जाता है. जस्ट अ सेकंड, लेट मी. ओके, इसको मैं just a second, right? Let me explain it to you again. Communities come to the communities who ask for ST status. They go to the state government. State government approve करती है. State government approve करती है. Then it sends to the रजिस्ट्रार जनरल ऑफ इंडिया. रजिस्ट्रार जनरल ऑफ इंडिया वो प्रपोजल्स अगर अप्रूव करती है, अगर अग्री करती है उन प्रपोजल से, तो फिर जाता है सेंट्रल गवर्नमेंट को. सेंट्रल गवर्नमेंट वंस द सेंट्रल गवर्नमेंट रेफर्स, मतलब अप्रूव कर दिया सेंट्रल गवर्नमेंट ने, देन सेंट्रल गवर्नमेंट रेफर्स इट टू द नेशनल कमीशन फॉर शेड्यूल्ड ट्राइब्स, ओके, for their recommendation. If the National Commission of Scheduled Tribe also recommends for the case, then the matter is processed by the decision of the cabinet after consulting the concerned ministries. जो भी concerned ministry है उनको consult करके फिर ये matter parliament में place होता है, parliament में as a bill. Okay, then this is placed in the parliament as a bill. Okay, once bill to amend the presidential order, ठीक है, bill to amend the presidential order. Once this bill is passed and the presidential order is amended, then it becomes a public notification. Then basically once the amendment is passed, the particular communities who had asked for the ST category, the ST status, then they are granted the scheduled tribe status. Okay, I hope this is clear. All right. Okay, so let's move ahead with another news item. So another news item is leg up for all tongues, no Hindi imposition Shah. So this article basically talks about that the central government is not trying to impose Hindi on other states, but is actually trying to promote other regional languages, right? So let us read about what are the provisions under our constitution related to languages. पार्ट थ्री, जो कॉन्स्टिट्यूशन का पार्ट थ्री है, ठीक है, दैट इज फंडामेंटल राइट्स, उसके अंडर आर्टिकल 29 आता है. आर्टिकल 29 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया स्टेट्स दैट इट प्रोटेक्ट्स द इंटरेस्ट्स ऑफ माइनॉरिटीज. नाउ माइनॉरिटीज कई तरह की होती हैं, राइट? माइनॉरिटीज, minorities can be, just a second, minorities can be religious minorities also, right? They can be religious minorities, they can be linguistic minorities, right? They can be cultural minorities, more or less linguistic and cultural same. So article 29 of the constitution, the article states that any section of the citizens who have a distinct language, script or culture of its own shall have the right to conserve the same. Okay, so this is what article 29 talks about. Article 343 is about the official languages of the official language of the union. Okay, article 343, official language of the union. Um, According to this, Hindi in Devanagari script and numerals should follow the international form of Indian numerals. This article also states that English will continue to be used as official language for 15 years from the commencement of Constitution. Article 346 is about official language for communication between states and between a state and the union. So this article states that the authorized language will be used, that is English. If two or more states agree that the communication shall be in Hindi, then Hindi may be used. So official, the language for communication would be English. All right. Then Article 347 gives the president the power to recognize a language as an official language of a given state. So 347 में president के पास power है to recognize any language as the official language of a particular state. ओके, सो स्टेट की जो लैंग्वेज है उसको रिकग्नाइज करने का पावर प्रेसिडेंट के पास है अंडर 347, राइट? सच रिकग्निशन कैन बी आइदर फॉर अ पार्ट ऑफ स्टेट और फॉर द एंटायर स्टेट. Then Article 350 capital B provides for the establishment of special officer for linguistic minorities, right? Then 8th schedule, we all know कि languages are basically covered under the 8th schedule of the constitution. 8th schedule में कितनी languages हैं? There are 22 languages recognized currently. There are 22 languages that have been recognized. और last जो 4 languages add हुई थी 2004 में, 1992 में amendment हुआ था, 2004 में basically Bodo, Dogri, Maithili and Santhali were added. These are the latest languages that were added to Bodo, Dogri, Maithili, just a second, Maithili and Santhali were added, right? These were the last languages, last 4 languages that were added. And there are demands for various languages to be added in the 8th schedule. So बहुत सारी languages हैं, भोजपुरी, छत्तीसगढ़ी, बुंदेलखंडी, राइट, गोंडी, कच्छी, बहुत सारी ऐसी लैंग्वेजेस हैं इंडिया में जो कि ऐड अभी तक नहीं हुई हैं, रिकग्नाइज नहीं हुई है कॉन्स्टिट्यूशन में, 8th शेड्यूल में नहीं है, पर दे आर डिमांड्स फॉर अराउंड 38 लैंग्वेजेस हैं जो कि अभी ऐड होनी बाकी हैं, राइट? एंड वो अलग अलग रीजन्स में मेजर लैंग्वेज का काम करती है. So the present status on inclusion of languages in 8th schedule as the evolution of dialects and languages is dynamic, influenced by socio-political developments. All right. So again, ये जो languages का जो पूरा the entire this languages, ये apart from part 3, part 17 का भी, sorry just a second, okay, this is, I'll write it here. So apart from part 3, part 17, uh, part 17 of the Constitution of India also deals with languages. All right. Okay. ठीक है. So this is what is important from your exam point of view. अच्छा, next is Jay Shankar discusses LAC with Quinn, Gold talks with Lavrov, but not Bhutto. Okay, so this is from your public international law point of view. So we'll be discussing the various international bodies and international groupings that have been discussed here in this article. So first is G20. They've talked about G20. So G20 or group of 20 is an intergovernmental forum comprising of 19 countries and EU. Okay, 19 countries. This includes 19 countries plus European Union. The G20 is composed of most of world's largest economies, both industrialized and developing nations, and accounts for around 90% of gross world product (GWP), international trades, and two-thirds of global population, half of world's land area. Right? G20 was founded in 1999. These are groupings, so उनके obviously because these are groupings, so they don't really have any particular headquarters organizations के होते हैं. These are international groupings, यानी countries, कुछ countries specific मिलके common जो भी commonalities हैं उनके ऊपर groups form करती हैं. ठीक है, be it trade or be it economics or be it anything. If they are fighting terrorism, तो terrorist anti-terrorist groups की भी grouping है basically. So there can be any cause, उस कॉज को लेके जो भी देयर आर मेंबर नेशंस, so they form one grouping pertaining to that particular cause. ठीक है. Next grouping that has been talked about in the article is BRICS. So BRICS basically stands for, this is Brazil, then Brazil, Russia, India, China, and South Africa. Okay, so BRICS is an important grouping, and it influences global economy. Brazil, Russia, India, China, and South Africa is an important grouping bringing together major emerging economies of the world. Okay. Now, it was initially formulated in 2001, right? The BRICS countries have been the main engines of global economic growth. They constitute for 41% of the world's population, 24% of the world's GDP, right? And then let's go to SCO. You all know you should know the different groupings. The SCO is Shanghai Cooperation Organization. SCO is a permanent intergovernmental international organization, and it's a Eurasian political, economic, and military organization aiming to maintain peace, security, and stability in the region. So SCO का basically SCO was earlier known as Shanghai 5. Shanghai 5 जिसमें 5 देश थे, राइट. 5 देश थे, कजाकिस्तान, चाइना, किर्गिस्तान, रशिया एंड ताजिकिस्तान along with चाइना. तो ये 5 कंट्रीज वो हैं जो कि चाइना के साथ they have basically they either share borders or they are पुराने टाइम से they have been uh, trading partners for with China. Okay, so Shanghai 5 1996 में आया था, and India and Pakistan became members in 2005. So Shanghai 5 was in 1996, और 2000 एक 2001 में it was this particular grouping was named renamed as the Shanghai Cooperation Organization, And then India and Pakistan joined in 2017. India and Pakistan became members of Shanghai Cooperation Organization in 2017. And अभी latest member जो है, Iran became a member in 2021. Iran became a member of SCO in 2021. All right. Basically SCO का जो agenda और जो purpose है, it basically talks about border demarcation, demilitarization talks, and और ये जो 5 countries थी, 5 countries कौन सी थी? कजाकिस्तान, and China and Kyrgyzstan, Russia and Tajikistan, right? तो ये जो 5 countries थी, ये 5 countries they had border with China as well. They shared border. So border demarcation, demilitarization, and of course now why the countries who shared border with China have now been included as part of SCO. Let's understand the difference between LOC and LAC. I know it's legal se thoda hat ke hai, it's slightly GK, but it's important to understand. India has some border related conflicts with its neighbors like China and Pakistan. These border conflicts have played major role in outbreak of wars, right? So just to understand, LOC is basically demarcated military marked frontier separating India and Pakistan occupied Kashmir. That is LOC, right? India and POK, that's Pakistan occupied Kashmir. And LAC is an unclear border demarcated between India and China. So India and China do not really agree upon the demarcation. All right, that's the basic dispute. And another news item also related to public international law is wherein international organizations and groupings have been discussed is this SEO ministers meet today to discuss economic ties. Now they have actually talked about Quad. So what is Quad? Quad is basically a grouping of 4 democracies: India, Australia, US, and Japan, right? And all 4 nations find a common ground for being democratic nations. And so they basically they were fined. This Quad came into picture in 2017. All right. And another grouping, international grouping that has been discussed in the article is IBSA. It is a trilateral grouping. IBSA में कौन है? That is India, Brazil, and South Africa are part of IBSA. Okay. Idea is the main idea basically is the main idea is South-South cooperation, because now of course India has announced that it will be, India has declared it is going to become the voice of the global South. So again, the idea of South-South cooperation, right? So IPSA is quite recent this thing. All right. So next, the final article for today is Stop Caste Survey Immediately. High Court tells Bihar government. This can be viewed from constitutional law perspective. What they are talking about is that caste census. When we talk about socio-economic and caste census, it is not really conducted by state governments, right? That is why the High Court is saying that because it is not your responsibility, so it is the responsibility of the Ministry of Rural Development and Ministry of Housing and Urban Affairs. The socio-economic and caste census, that is SECC, they are published by Ministry of Rural Development. They're published by Ministry of Rural Development and Ministry of Housing and Urban Affairs. Housing and Urban Affairs. All right. The SECC reports are available on secc.gov.in, and they are informed by Ministry of Social Justice and Empowerment. Also, Ministry of Social Justice and Empowerment. Now, there are various types of census that are conducted in India. पॉपुलेशन सेंसस होता है, हर 10 साल में पॉपुलेशन सेंसस होता है, ओके, जो कि डिटेल प्रोवाइड करता है डेमोग्राफी की, सोशल इकोनॉमिक कैरेक्टरिस्टिक्स, जो भी सारे फंडामेंटल्स सोशल फैक्टर्स है, इकोनॉमिक फैक्टर्स हैं, वो सारे वो पॉपुलेशन सेंसस से डिटर्मिन होता है, जो कि हर 10 साल में लिया जाता है. फिर होता है हाउसिंग सेंसस, जो कि हाउसिंग कंडीशन और अमेनिटीज पे के लिए लिया जाता है, हाउसिंग उस पे डिटेल्स प्रोवाइड करता है. Then another is agricultural census. Agriculture census provides information on agricultural sector, including land use, irrigation, crop production. Then there is livestock census, which provides information on the livestock population, including cattle, buffalo, sheep, goats, pigs, poultry, etc. Right? And then there is also economic census. Economic census is conducted to collect information on the non-agricultural sector, including businesses, industries, and employment. And then there is, of course, the socio-economic and caste census. So this is a comprehensive study of socio-economic caste of rural and urban households. So SECC includes a caste census which provides for information of caste composition of the population, right? um, So, what is the difference between population census and caste and the SECC? The census provides a portrait of Indian population, यानी जो population census है वो Indian population का portrait देता है, but जो SECC है, that is the socio-economic and caste census, it provides a tool to identify beneficiary for state support. Beneficiaries of state support, okay, क्या कौन कौन beneficiaries हैं? तो SECC is basically SECC is basically, it is a tool to identify beneficiaries. Beneficiaries of state support. Okay. Um, right. All right. So and जो ministry है, they basically undertake the caste census and not the state government. And yeah, this is one information that you need to know. Um, there is a Registrar General and Census Commissioner of India. Registrar General and Census Commissioner of India. Currently, Shri Mrityunjay Kumar Shri Mrityunjay Kumar Narayan is the current Registrar General and Census Commissioner of India. Okay, all right. Okay, so yesterday, due to power cut, the streaming had stopped, and there are certain articles that were remaining. So let's just quickly look into those articles that were remaining from tomorrow's session. We'll quickly go through these. So yesterday we were talking about the EU's Artificial Intelligence Act. That is, European Union has introduced its Artificial Intelligence Act. It can now this act basically provides a framework for artificial intelligence. It also provides General Data Protection Regulation, yeah, GDPR, that we talked about yesterday. It also provides different artificial intelligence tools according to perceived risk levels and imposes different obligations and transparency requirements. It also talks about includes chat GPT, various chatbots, right, and multiple tools for performing different functions. Now let's see what has India done. तो हमने EU का समझ लिया कि EU यूरोपियन यूनियन ने क्या किया, बट इंडिया ने अभी तक इस कैटेगरी में, इस पर्टिकुलर उसमें अभी तक, बिकॉज वी स्टिल डोंट हैव अ लॉ पर से, बट नीति आयोग हैज इशूड सम गाइडलाइंस. Niti Ayog has issued some guiding documents on AI issued, such as AI issue. Basically, Niti Ayog का एक document है. The name of the document is National Strategy National Strategy for Artificial Intelligence and the Responsible AI for All report. Responsible AI for All. Okay, this is the name of the report. Name of the report by Niti Ayog. You can go on the Niti Ayog website if you want to study this report. And the National Strategy for Artificial Intelligence and Responsible AI for All report. ये एक important point है आपके legal current affair के लिए. This can be asked. Okay, artificial intelligence पे अगर discussion हो रहा है तो they are not going to ask you the EU Act or the European Union Act. They might ask, okay, किस country ने अभी recently artificial intelligence पे act बनाया है? That it can be EU. But India ने क्या steps लिए हैं उस regard में? So that is the Niti Ayog report, or the name of the report can be important for you to remember from your exam static legal GK point of view. Okay. Now, this Niti Ayog report basically emphasizes on social and economic inclusion, innovation, and trustworthiness. Apart from India and EU, there is United Kingdom ने भी कुछ guidelines जारी करी हैं. There's United Kingdom. Again, China ने officially block नहीं किया है, but okay, let's not discuss China because China is a very different this thing. All right. So because there are concerns related to AI software and chatbots. That's why it is important now for the countries to frame guidelines, or at least you know, draft laws pertaining to these issues. All right. Next article that we had to discuss yesterday was the Kerala story is Supreme Court tells petitioners to approach High Court for disclaimer. Now, in this article, what is important for you to understand is the power of High Court under Article 226 of the Constitution of India has been discussed. Article 226, Article 36, Article 32 में Supreme Court की power discuss करी गई है, right? The remedy, right to the constitutional remedy has been discussed, but article 226 में high court की power discuss करी गई है. The power of high court to issue writs, and basically it's a constitutional to it is a constitutional remedy provided to all the citizens under article 226 of the constitution. अच्छा, difference ये है, ये जो 32 है उसका जो एम्बिट है वो थोड़ा छोटा है एज कंपेयर टू 226. 32 में अगर आप सुप्रीम कोर्ट डायरेक्टली जा रहे हो तो आपका सिर्फ अगर फंडामेंटल राइट वायलेट हुआ है, only if your fundamental right has been violated, only then you can directly go to the Supreme Court under Article 3 under Article 32. ठीक है, यानी कि ये only if this directly only if fundamental right is violated. But under Article 226 of the Constitution, along with fundamental right, even if your constitutional or legal or any मतलब statutory right कोई भी वैसा violation है, In those cases also you can approach High Court under Article 226, or you can take the help of writs, the different writs. Okay, this is enshrined under Part 5 of the Constitution, which provides High Court with the power to issue writs, including the writs of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, and any of them to any person or authority, including the government. Article 226 of the Constitution gives High Courts the power and ability to enforce any of the basic fundamental rights guaranteed under Part 3 of the Constitution, right? Article 226 within India's territorial jurisdiction has ability and power to issue orders, instructions, writs to any individual or authority, including the government, for the enforcement of Part 3 of the Constitution. 226 Clause 2 empowers High Court with the authority to issue orders, instructions, and writs to any government authority. And 226 also gives the power to the High Court to issue instructions, orders to any person, authority, including governments. All right, so I hope you understood the basic difference between 32 and 226. 32 is a fundamental right, but 226 is a constitutional right, because 32 part 3 में आता है, so it is a fundamental right. 226 is a constitutional right. Okay. 32 can be suspended if the president declares an emergency, but Article 226 cannot be suspended even during an emergency. 32 has limited reach since it only applies to fundamental right, but Article 226 has wider application. Article 32, the Supreme Court has the authority to issue writs across India, and 226, that is only subjected to the local jurisdiction, that is the state jurisdiction. All right, okay. So I hope you understood the difference between Article 32 and 226 of the Indian Constitution. Then the next article that we had to discuss yesterday was Supreme Court Collegium rejects IB observation about candidate for High Court judgeship. This is a constitutional. This is directly related to the constitutional law, and it basically talks about appointment of High Court judges, and it also talks about the collegium system. The High Court is state's highest judicial court, and it is country's second highest court. And the Indian Constitution establishes High Court in every state. So, right, the High Court Article 2. So there are also common high courts for for some of the states, right? And when we talk about appointment of High Court judges, the judges of the High Court are also appointed by the President. The President appoints the Chief Justice after consulting with the Chief Justice of India, Chief Justice of a High Court after consulting the Chief Justice of India and the Governor in the state in question. The Chief Justice of the relevant High Court is also consulted for appointment of additional judges. Okay, so let's talk about the appointment of judges of the High Court. The judge of a High Court appointed by President, President appoints the CJI of the Chief Justice of High Court with consultation with in consultation with CJI and Governor of the state. ठीक है? और चीफ जस्टिस जो हाई कोर्ट का चीफ जस्टिस होता है उसके साथ कंसल्टेशन के साथ the other judges of the high court are appointed by the president. Okay, and the judges of the high court are appointed by the president in consultation with the members of the judiciary, that is the Chief Justice of India and Chief Justice of the High Court. There are, of course, when we talk about the collegium system, there are a slew of case laws important. The appointment, when we talk about appointment of High Court as well as Supreme Court judges, the case laws, basically the issue of appointment of judges to High Court and Supreme Court has actually evolved through various case laws, right? And you'll see that there are first, you can refer to your constitutional notes wherein the first judge's case, second judge's case, third judge's case has been discussed, and the recent amendment, the recent amendment related to the NJAC. Okay, so NJAC was National Judicial Appointments Committee Commission, which was uh, scrapped in 2015 by the 2015 constitutional amendment, 2015 constitutional amendment. Sorry, the constitutional amendment in 2015. Right. All right. So let's talk. The another article that we need to discuss is regarding the SC/ST Act. That is the Scheduled Caste and Scheduled Tribe Act. The SC/ST Act 1989 is an act of parliament enacted to prohibit discrimination against the SC and ST community members and prevent atrocities against them. The act also recognizes, it basically provides the recognition of depressing reality that despite undertaking several measures, the SC and ST community members continue to be subjected to various atrocities. Okay, so SC/ST Act basically provides provisions for protection of SCs and STs, protection of members of STs and SC and STs, and there are also several articles under the Constitution of India which uh, support this particular act. Article 15, Article 16, and Article 21, 15, 15, 17, and 21, right? As well as 16, sorry, 15, 16, 17, and 21 of the Constitution of India. And recently in 2018, the SC/ST Act was amended. 2018, the SC/ST Act was amended, or उस amendment में the preliminary inquiry now is not a must and no prior approval is required for appointing authorities for senior police officers to file FIRs in cases of atrocities in SC/ST Act. Okay. So next article relates to guidelines on allotting space to feed stray dogs welcomed. Housing societies and animal feeders in Mumbai welcomed the center's guidelines to allot dedicated places and time to feed stray animals. In March, the Ministry of Fisheries, Animal Husbandry and Dairying notified that the animal birth control rules, which put the onus on the resident welfare associations and apartment owners associations to ensure a feeding spot and time for residents to give food to animals. The rules read: the feeding spots shall be far from children's play areas, entry and exit points, staircases, and should be in an area which is the least frequented by children and senior citizens. And RWAs or AOAs should designate feeding times depending on the movement of children and senior citizens. So this particular article is also basically related to, it talks about animals' rights. It talks about, it is also related to Prevention of Cruelty to Animals Act of 1960. It's a very important act. It is one of the most comprehensive laws on the subject of animal welfare in India, and this was passed in 1960 with a vision to prevent cruelties on animals. The act prevents unnecessary pain or suffering on animals. The act enshrines provisions for establishing animal welfare board in India. So we have an animal welfare board in India, right? And of course, the act also specifies the powers, functions, constitution on members, everything regarding to the animal welfare board. And the act enshrines the guidelines regarding experimentation on animals for scientific purposes and empowers the committee to make rules with regards to such experiments. The act restricts the exhibition and training of performing animals, and exhibit and train are separately defined under the act. Okay, right. Another article is related to, it talks about US pick Ajay Banga confirmed as next president of World Bank. Now we need to understand, of course, this is related to your legal GK aspect, is your legal GK point as well. So recently, we need to understand World Bank. what World Bank, what is this organization, international organization World Bank, right? It was created in 1944. It was earlier known as the International Bank for Reconstruction and Development. At that time, IBRD, along with IMF. Along with IMF. These are basically Bretton Woods institution. Okay. The World Bank Group is a unique global partnership of five institutions working for sustainable solutions and which reduce poverty and share prosperity in developing countries. United Nations specialized agencies, one of United Nations specialized agencies. And there are 189 member countries to the World Bank. India is also one of them, right? So World Bank basically publishes ease of doing business report, human capital index, world development report, and there are several organizations, several institutions which are attached with World Bank, right? What is the difference between World Bank and IMF? World Bank provides supports to developing countries, and IMF aims to stabilize international monetary system and monitors world currency. So this IMF monitors world currencies, and World Bank provides support to developing countries. Okay. Now next article talks about WTO, the World Trade Organization. So India to be the voice of the global south. The World Trade Organization is again a global international organization dealing with rules of trade between nations. It has WTO has 164 member countries and 23 observer member countries and 23 observer countries, right? WTO's global system lowers trade barriers through negotiation and operates under the principle of non-discrimination. The result is reduced cost of production. All right, so for your exam point of view, you need to understand when WTO came into picture. WTO basically the World Trade Organization came into picture in 1995. उससे पहले 1995 से पहले GATT था, which was General Agreement on Trade and Tariff, right? So you need to know certain facts for your legal GK point of view, because this is part of your static GK as well. Okay, so all right, so we are at the end of it. You can join the Telegram channel for I'm starting to upload this from today onwards. I'll be uploading the PDFs as well, so that you can so that you don't need to take notes. You will be provided with notes of the current affairs as well for your better this thing for reference. Okay, all right. Thank you.